Very often I hear this scenario, and it's very common these days because marriage and divorce is a very common thing. People come to my office, one woman in particular recently. She told me she had gotten her green card 4 years ago through marriage to a prior spouse, and then she was divorced about a year or two ago, and now she's about to get remarried in the next few months, and she wants to know if she, as a green card holder, can sponsor her new soon husband-to-be. And it's a little bit of a complicated answer. Immigration generally holds to the rule that if you got your green card through marriage to marriage to a spouse, then you must wait 5 years until you can convey any sponsorship benefits on a subsequent spouse. There are several exceptions. One exception is if you can prove that there and show the bona fides of your first marriage and that you were not married just to evade the immigration laws. The most common example would be birth certificates of children born to that marriage. Then you wouldn't have to worry about waiting 5 years. The second example is if your marriage terminated through death of your first spouse, then there's no issue of bona fides. But in general, if you did not have any children together and your marriage was terminated through divorce and not death, then you must wait 5 years until you can sponsor your spouse-to-be. You can get married at any time, but it will not be possible to file the papers. It will be difficult to get an approval by immigration if you do not wait 5 years. This is a little bit tricky, so I would recommend, if you have a scenario like this, to be in touch with our office. We have handled many cases like this and helped people prove the bona fides of their marriage and had a successful outcome for the second sponsorship. Thank you.